that will empower you, particularly as we get into the Christmas season and you're about to buy things, make all sorts of purchases. What are your rights as a buyer? Don't go anywhere. We'll be right back. You're welcome back. This is the law. It's your legal light. It is your health law. And this afternoon, we are going to the classroom, but in a way that you will benefit greatly. I have in the studio Jude Atakra Tofo and Kweku Atakra Jumo. These two are lawyers, they are authors, and they are teachers of the law. Gentlemen, good afternoon and welcome to the law.
Thank you
Right.
very much.
So as we always do, we take you through our 2 minutes of some rare legal education. And this afternoon, the Law 101, we are asking what it means when the lawyers say caveat emptor. What does it mean when the lawyers say caveat venditor? So, beginning with any one of you, what do these two Latin expressions mean? Caveat emptor.
Thank you for the opportunity, Samson. And let me start by saying that when we use the expression caveat emptor, we are basically referring to a situation where we require the buyer of any sales transaction to be aware of the goods that buyer is getting involved with. If you, in Ghana at the moment, that is not the case per se.
Okay.
Prior to the passing of the Sale of Goods Act, which is a law which regulates sales transactions in Ghana, caveat emptor was a law. It was a baseline. But when we passed our Sale of Goods Act, we then shifted from caveat emptor to caveat venditor. So then this moves me to explain what caveat venditor
means.
So caveat venditor basically, unlike emptor which says buyer beware, here it is an obligation on the seller to ensure that the goods which are the subject matter of the sales transaction are free from defect. So what we basically mean is that when a seller sells goods to a buyer, the seller must ensure that the goods which are being sold are not damaged or they don't have any problem with those goods in terms of its expected nature or the appearance. That is basically what we mean by. So the seller has that obligation to ensure that those goods are not damaged. That is, they should be free from defects. So
right.
In short, that is what these two principles mean.
Great. So Kweku, let the buyer beware. Caveat emptor.
Yeah.
Let the seller beware. Caveat venditor. What else can you say by way of, helping our audience?
So at least there are there are concepts on different ends. One places an obligation on the buyer to be sure that the good he or she is purchasing is free from defect. What that means is that basically the buyer, when you're buying, open your eyes. So if you're going to the market, let's say to buy tomato as a buyer, per the principle, you the buyer have the right to inspect the tomato. Is it the kind of tomato I want? Does it have any defects? Is it rotten? Is it whatever it is that is wrong? The obligation is on you, the buyer, to ensure that you point it out. The reverse is for the caveat venditor, where the seller has the obligation to ensure that what the seller is selling to the public is something that is fit for purpose. Okay. So the seller must be sure that the good is not a destroyed good, it's not a damaged good, it's not a rotten good, it doesn't have defects in it. Right? So there are two ends, and depending on where the law puts it, each party will have the obligation. So under a sale of goods, as Jude was saying, we more or less have a balance. So it's not solely or it's not entirely on the buyer, it's also not entirely on the seller. There's a balance that I'm sure we'll go into it. But it's basically caveat emptor puts the burden on the buyer to ensure that the good is fit for purpose for purchase.
You examine what you are buying.
Yes.
Okay.
If you decide not to examine it, the problem is yours.
Okay.
The same way with the caveat vendor, the seller must be sure that what he or she is giving to the public is fit for purpose.
Great.
So if you can also let's us put this in context.
Okay.
So, like I said, prior to the passing of the law which regulates Sale of Goods Act, buyers had an obligation which was mandatory. That's why we have the caveat emptor. Now, the position of the law under Section 13 of our current law is that as a seller, where the caveat vendor comes in, as a seller, whatever you are selling should be free from defect. However, in a situation where the buyer is given the opportunity to examine goods, and the buyer ought to have noticed or notified any obvious defect in the goods, that is where the principle of caveat emptor would kick in.
Okay.
Right. So
All right.
that is basically what I wanted to share.
Thank you very much. And on my Learned Friends platform, somebody asked the question, are you sure your producer didn't get the spelling of the first Atakara wrong? Because there is Atakara with one T, and the next Atakara is with double T. So Jude has one T, and Kweku has a double T. And I was telling Jude a while ago, Kweku a while ago, that the first time we had a show with him on this program, he was here with Dennis Ejay Jumo, and he is Kweku Atakara Jumo. People were asking, are they related? Today, the questions I have had has been whether the two of them are related. And here is the answer. Today I'll answer, yes, they are related. How are they related? Here. They are co-authors or joint authors of this book. We'll give you a lot more about it. So just get ready. They will teach you almost everything that you need to know about your right as a buyer when you go into the market or get into any transaction. And of course, if you're also listening and you are also doing any transaction and you are the seller, then you must also recognize that you can also learn from it. So first of all, thank you very much. Law 101, caveat emptor and caveat venditor. I'm sure that you have gotten some lessons from that. Okay, so once again, Jude, as we are getting ready to get into Christmas, people are going to do a lot of shopping, and those who bring us the good will buy a lot of goods so that they can sell. When we say sale of goods or a contract of sale, what do we mean? And you started right away by introducing us to the Sale of Goods Act.
Right. The contract of sale is an important expression because it is the very first provision. Again, I'll be referring to the law which regulates sales transactions in Ghana, which is the Sale of Goods Act 1962 at 137. And the very first provision says that for any sales transaction, the subject matter, which are the goods, are important. They need to be in existence. The party, that is the buyer and the seller, must be in existence. And most importantly, the ability for the seller to transfer or to sell those goods to the buyer, which is that in law we call something property, transfer of property, which I believe Senior is already aware of. So the ability to transfer ownership or property to the buyer is also what is important for a consideration called price. Yeah. So when we say contract of sale of goods, is basically a contract between a buyer and a seller, where the seller has or the seller is vested with ownership,
right?
So that the seller will be able to transfer that ownership to the buyer for price, in exchange for price.
Great.
Right. Which can, the law says either wholly or partly. Yeah. So that's basically what it is.
Okay.
Yeah.
So we move on, and I'd like Kweku to help us understand, as we see that their prices are going up today, tomorrow. When I buy a thing today and tomorrow the prices are higher, does the law regulate such acts?
Well, currently, Currently, under the Sale of Goods Act, no, there's no law that regulates prices. I mean, basically, prices have been left now to demand and supply. So supply sometimes can decide to hoard goods and so that the prices can shoot up. So under the Sale of Goods Act, no, there's no regulation for that. But more importantly, and there's always been that call for us having a Consumer Protection Act.
That's right.
Because now there's no way consumers are protected in any way. If I walk into a shop and they tell me that the good is 1 million, let's say I'm buying this pencil and they tell me it's 1 million, all I can do is just walk away. But there's nothing to protect me to say that, no, this is taking, or by selling this for 1 million, is taking advantage of the market.
Recently, the president had to complain, and he was right, because in truth, there are sellers or traders who are exploiting our current circumstance and are selling at exorbitant prices. And the state cannot do anything about it. Is that what you mean?
Yes, because now everything, as I said, is demand and supply. So if you walk to the person says, you're even selling a sachet of water for this amount, all you can do is just walk away. There's not much you can do in terms of the law, and that's why the president may only have to lament. Because then there's no law regulating that. Now, if you go to other jurisdictions...
He lamented and appealed. Right.
But if you go to other jurisdictions, UK and the rest, they do have antitrust laws, consumer protection laws, and what have you, where it protects the consumer so that you don't have the seller exploiting you just because it's an open market. So under a Sale of Goods Act, no, there's not much that can be done. But we've always been calling for that Consumer Protection Act so that consumers too can be protected from that vast space of an open market where sellers can come together and say, we are selling this at this price and there's nothing you can do.
Right. So just a while ago, you explained to us what the sale of goods or contract of sale of goods represents. But often when we are talking about this, we seem to be talking about very tangible things, like I'm going to pick a copy of this book. You know, does the law cover, or the sale of goods cover intangible things like, you know, software issues?
I'm happy you have asked this question because most often than not, this is a question which comes up a lot, whether intangibles are part of goods.
Right.
And my straightforward answer is no. And the reason I say no is that if you read the law, especially under Section 81, it's very clear as to what the definition of goods are. It says goods are every item of movable description. Okay. So when it uses the expression movable description, it again suggests and informs us that we are referring to items that can be moved from place to place, and also items which are also fixed to the ground and that can also be the subject of harvest. However, I must point out that in other jurisdictions, like in India, the Sale of Goods Act of 1930 shows in actions like the transfer of shares, transfer of stocks as part of goods. They all form part of goods. So, for instance, we have instances where people will call and ask you, I just purchased an app from the internet.
Okay.
Yeah, or on maybe an app from your Apple phone or whatever. Would it cover the Sale of Goods Act? And again, the answer is no. The reason is that the law is clear. So by the definition of what goods mean, intangibles like transfer of shares, transfer of stocks, and also by what we are talking about, intangibles or like software apps are not applicable. So the question then again is that, what are your rights in respect, or what area of law will these transfers cover?
Great.
So if it has to do with shares, of course it will be regulated by the Companies Act. If it has to do with a software application, it's regulated by the IP rights. Okay, so they have to do with IP rights per se, and not the Sale of Goods Act.
Yes, you wanted to say something, but I wanted us to bring in, because there's one issue that often when I sit on this show, people have come to ask a question, and they're asking about the lack of satisfaction of the services of a lawyer. So you say what you have to say, then I'll bring in the question of services, because we are talking about goods here, and since there is no direct application to software apps, as has been explained, then I wanted to bring in the question of services. And whether there is relief for people who, and hire the services of other persons for whatever reasons.
Okay, well, yes, in the definition Jude gave of a contract of sale, it's quite specific to say that it regulates goods, of which goods, the definition of goods under Section H1 of the Act is clear to say that movables. And so that's where the case law usually seek to shy away from issues of services or intangibles. Now, even under law, there's a decision of court, Halabi and Redu. Now, in that case, the court was quite express to say that.
I told you were going to be in a law class. So learn.
Right. Now, in the case of Halabi and Redu, the court was, because there was an issue of a sale of goodwill. Now, the court held that goodwill is not a tangible, it's not something that's a movable. So it can be regulated probably in a general contract, but for purposes of sale of goods, the emphasis of the goods in there is on movables. So your mobile phone, your books, your vehicle, a car or something, but not something we can't hold. So now tying that in with services, in fact, I think in UK, there's been a tall discussion on this matter on whether services will amount to a good in law. I think one of those cases, is it a Griffin? Lee and Griffin. Yes. Yeah, and Clear and Yates, yes. Yeah. Now, in this line of cases, they hold that services do not amount to goods unless the service is to lead to an end product of the production of a good. Yeah. So probably if I hire, let's say, the service of a carpenter to make an artifact for me, probably we may consider that transaction because the end product is a good.
Right.
Now, tying with the lawyer, because your hiring of your service of a lawyer, I'm not sure the end product is to produce a good. So at the end of the day, the lawyer's service may not come under the Sale of Goods Act.
Right.
It won't constitute as a good. Probably if you are dissatisfied with your lawyer, the Legal Profession Act gives you a redress. You can whether take him to the General Legal Counsel, or you can even sue him to whether it's an issue of whatever it is.
Right.
But then at least for purposes of the Sale of Goods Act, services of the lawyer may not constitute a good.
And again, most importantly, if we deem it so relevant and important to have these intangibles as part of goods, Parliament should make it clear.
Okay.
As far as our law is concerned, we don't have such. Okay. I'm really happy
this
question.
Is it advisable for Parliament to do such a thing?
We are in 2022.
That's
Our
right.
law is quite old, 1962. In respect of the intangibles, because in other jurisdictions and the issue, let me also make this clear. There have been other cases in court, some of them are recent, where this act was referenced to lead to conclusions or decisions in respect of whether or not indeed transfer of shares or stocks will be subject to this.
Okay.
And our judges rightly so argue that indeed.
What's the benefit or advantage in including intangibles, services, to represent the gamut called goods?
At the moment, the obvious benefit is that at least we'd have a law regulating these things. Okay. We don't have any at the moment, okay? So that's the obvious benefit. But whether indeed, again, goods can be regarded as movables or immovables is something that we need to address.
All right.
Okay? Other than that, we'll be including things like houses, like land and all that as part of goods, which may cover a whole lot of things. So that may be an obvious disadvantage. Right.
Kuku had spoken, for example, in response to the question about services, and I referred to a lawyer, about your recourse to the General Legal Counsel. And we have seen situations where they have suspended lawyers, they have handed them bans, some have lost their license to practice because of unethical conduct. But if that exists, then what's the point? And if I'm engaging you for services and there will be a contract which will bind the two of us, what would be the point in wanting that to be regulated by public law?
Well, the advantage of the Sale of Goods Act, for instance, because ordinarily, if you purchase a good, there's a contract you would have entered into. But then the Sale of Goods Act provides for what we call implied terms. some terms that you not include in your ordinary contract, but if it qualifies as a sale of good contract or a contract of sale, the law imposes it on the buyer or the seller.
Okay.
Right. So, because if you even look at it, take the ordinary person on the market. If you go to the market to purchase, the person selling tomatoes may not have the opportunity to sit with you. Let's write a contract. Let's include that if I don't deliver, this will happen. They may not have the opportunity to do that. So then that's why there's a need for a law to step in, so that you may even not have a written contract, but the law will impose that if this is the kind of contract you want to have, we will impose that these are obligations on both parties by default.
I think it's becoming very clear to you what the advantage is as far as the transaction you enter into as regards goods, sale of goods, covered by the Sale of Goods Act. This is the law. It is your legal lights. It is your help law. And this afternoon, we are very privileged to have Jude Atakra Tufo and Kweku Atakra Jomo, who are authors of Atakra and Atakra on Sale of Goods, to help us to understand some of these things as we begin our Christmas purchases and various transactions. So, will you say when people engage in, say, barter trading, when a person promises another person a good for a good or service for service, the sale of goods will apply? Because you just gave a good illustration where the sale of goods actually will help, the Sale of Goods Act will help the vulnerable.
Well, the Act is quite specific on the kinds of contract it relates. And when Jude mentioned, he mentioned one of consideration or price. Now, the Act is expressed to say that for you to obtain protection under the law, there should be some form of payments for the good you are purchasing.
Right.
And the Act provides that the purchase need not be, or the payment need not be complete or in full. You can pay in part. So at least there should be some money moving to the next person. Now, with barter trading, well, my understanding is that I have a shoe, I come for your jacket, or I have your spectacles, I come for your mobile phone or something. There's no money moving in that transaction. And so that won't qualify as a contract. So even though I ought to protect them, but then the law is quite express to say that there should be some money moving. Even if it's a CD or two, then we know that we've broken the chain of barter trade and we brought it under the Act. But if it's solely an exchange of good for good, no, it won't be covered under the Sale of Goods
We
Act.
just talked about software issues. It takes me to online, because these days we are making a lot of transactions online.
Right.
Does this law apply to give me protection?
Again, I'm also happy you have asked this question. Online is now the order of the day.
That's right.
And
sit here and we order things from abroad, anywhere.
Anywhere. So there are a lot of things that comes to mind when we consider online transactions. The first is that it is not obviously covered by our Act. Okay? However, when you engage in an online transaction, you must understand that the Sale of Goods Act can be invoked. There are three levels that I would want to look at this. The first is that there are some type of online platforms which may necessarily bring into being the Sale of Goods Act. The first is what I call a direct transaction. For instance, transacting on platforms like Gigi or Tonaton, where you know that where an item is advertised, you don't necessarily buy the item per what you have seen. You will normally see the details of the seller, you engage the seller, and you transact with the seller. And at those instances, you may go offline. And in that, by that itself, you may be dealing with the Sale of Goods Act.
Right.
So that is point number one. Point number two is where you have third-party online transactions. Third-party online transactions, you are looking at platforms like eBay, if it still exists, Amazon, and in Ghana here, I think we have Jumia. Right. Jumia. So you don't...
I'm sure this is on Amazon. I can buy this from Amazon. Amazon?
No, not yet.
Okay.
Not yet, yeah. We are working on to put it on Amazon.
Okay, yeah.
So the third-party online transactions is such that the person you are dealing with is not somebody that you don't really know the seller. However, when you go online and you select the item that you want, okay? So normally they'll put a description of the item there. Let's say it can be an iPhone. You want a particular LED type, you want the color, you want this. Those are descriptions which you fall in line with and what you engage in. Then, most importantly, when you select on the item and it goes to the basket and you pay for it, what is delivered to you is probably not what you saw. Yeah.
Yeah.
So, by that in itself, our argument which is in the book is that we believe strongly that this is covered by the sale of goods. Because the seller goes through a process to actually work out the specifications you have provided online to select exactly what you want and deliver it same to you.
Okay.
However, there's also one important thing that we need to mention. The online sales transactions must not be operated outside a particular law, which is the Electronic Transactions Act of 2008, Act 772. In fact, Section 47 lists a tall order of mandatory requirements for those who operate online transactions. That, especially for those who make it open for buyers to actually go on there and make sales, you are expected to provide your name, your address, your contact details, policies on alternative dispute resolution, policies on resolution in terms of the goods, and also refund policy. But most of these online platforms, they don't have such policies.
Yeah, now to talk about those who simply put it on WhatsApp and say, I have this, you can buy. Those who put it on their Facebook.
On Facebook and all that.
You can get this from me.
So I was actually discussing with Kweku and I told him that technically when you transact on these platforms, you are technically operating outside the law. So the extent to which a Sale of Goods Act may come to your assistance is when you comply with the Act 772. These mandatory requirements and that the Electronic Transactions Act. Other than that, unless maybe you want to invoke the instrument of equity. Yeah, but other than that, if you are going in accordance with law and statute, if you don't comply with Act 772, the Sale of Goods Act cannot come to your defense.
Talking about that, let's bring in quickly this, and starting with you, Kweku. Because there's a lot of this kind of transaction going on, people are selling, dresses, they are selling, particularly ladies, they're selling all sorts of stuff, cosmetics, perfumes, and all they do is to put on their profile, that they have this and that, and you can pick one. So you are on a WhatsApp group, and they just share it and say you can get this. On Facebook, they just put it there. Now, if they are not complying with the mandatory provisions of the Electronic Transaction Act, I, as a buyer, don't have the protection of the Sale of Goods Act. So, what are the duties of the buyer and the seller?
Well, good point you make, especially on, because as you mentioned, most of these online transactions is just somebody picking the phone or using an IG page, putting the good there and selling it.
Right.
And so really, the buyer is also at a disadvantaged position because you are buying from a source that is not regulated. The mandatory requirements of Section 47, as you mentioned, are usually not complied with. But assuming they have been complied with and as that their online transaction is a valid one.
Right.
Now with the direct form of online sales, so let's say that putting it when a person places on his WhatsApp or let's say the Instagram page. Now the understanding is that I'm transacting with a person, but we just have a virtual platform.
That's right.
Now because I am directly dealing with the seller, and because it falls under the direct kind of transactions and online, it means that the transaction ought to be treated as though we are dealing in person. Now, one obligation, one right of a buyer is that the buyer is entitled to the good. So if it's an unascertained good, that is, if you bought it by description, you are entitled to the good which substantially corresponds to that description. Okay. So if I purchase, say I see a blue jacket on your IG page, when you are delivering that jacket to me, it should be a blue jacket. If it's double-breasted, it should be double-breasted. We have sometimes you see it online, you see something like what I ordered versus what I got.
That's right.
You see that person would order for a very nice jacket.
Yeah.
You see the picture, but when it
especially
comes,
with our designers.
with the designers, you see that it comes in and it's something totally different. Now, by law, if the seller delivers something that does not correspond with the description you gave, the seller breaches his fundamental obligation under Section 8.
Okay.
If the seller breaches that fundamental obligation, the buyer is entitled to reject the good. So if I order for a watch, I say I want a smartwatch. Now it comes, you bring me just an ordinary watch. It doesn't meet the requirements of the description I give you. And if it doesn't, I, the buyer, I do have that fundamental right to reject it.
Okay.
Now the question may be that what if the buyer has already paid for the good? The buyer is entitled to recover the money from the seller. So that's a fundamental right the buyer has.
Fundamental.
Yeah.
What would be the fundamental right of the seller to?
The seller's right in a situation where the buyer fails to pay, one is that they are in two aspects. One is to consider the goods as an option, and one is to consider the human being. Okay? I don't want to use the word persona. Okay? Yeah. So the person or the entity, that is a buyer. So in terms of the rights or the remedies which are available to the seller, the first one is to exercise a lien. Okay. What is a lien? I mean, of course, there are lots of people watching, so let me just break it down.
That's right.
Okay. So there's a simple example is you give your car to your mechanic, you fail to pay. Your mechanic says that I won't release the car until I've been paid. So the mechanic is exercising a lien over that car. Yeah. Like
So in very ordinary parlance,
Yeah.
he will seize it.
Yeah, he will seize it. Thank you very much. He will seize it. Yeah. So the seller can exercise a lien so long as the goods are in the possession of the seller. That is, if the buyer hasn't paid for the goods and the seller has the goods in his possession, that seller has that right. Then we also have what we call the right of stoppage of goods in transit. And again, what do you mean by right of stoppage of goods in transit? One, it can be a carrier either by vessel or by truck haulage, or by any means of transportation. And what we mean by this is that once the seller has knowledge that the buyer has not paid, or that the seller's credit, or any mode of payment, either in the form of check or any bill of exchange, has expired or has bounced, I mean literally, the seller can communicate to the agent of the carrier, that is whether it's a truck haulage, to ensure that those goods are not released to the buyer. Okay, so that is what we mean by right of stoppage of goods in transit.
Right.
Okay.
So you can exercise a lien.
Or you can stop the goods from being delivered to the buyer.
Right.
Okay, so in simple expression, let me put it that way.
Okay.
And again, you can also recover the goods. So recovery of possession, you can recover the goods from the buyer
If the goods have already gone to
the buyer. So long as ownership has not been transferred. So if ownership is vested with the buyer, you can't exercise that right. Okay. So in law, ownership can be with the buyer, but you will be in possession of the goods. That is where you can exercise lien and stop the goods. Okay, from the goods getting to the buyer. But once ownership has transferred, you cannot recover the goods.
When do we say ownership has transferred? I'm buying something, I've sent you the money, you have sent me the thing. Here you are telling me some law that ownership has not.
It's quite fluid, and it's something that we don't see happening. Most people enter into sales transactions, and for them, the moment they buy the goods and they pay for it, for them ownership has passed. Okay, I've never. For all these years of practice and also teaching in the classroom, I've never come across a situation where ownership has been an issue in terms of entering a shop or ordering for goods and goods being delivered to you.
All right.
But usually when we say ownership, whenever you talk about ownership, you must consider one main thing, which is what type of goods are you dealing with?
Right.
Are you dealing with specific goods or are you dealing with unascertained goods? When we talk about specific goods, you are talking about goods which are the obvious ones. So for instance, I enter into a shop and I say, I like this TV. This is the exact TV I want, okay? So under our law, ownership passes under specific goods when the goods are delivered and also when it is subject to the intention of the parties, okay? The intention, and these are in sections 26, 1 and 2. The intention is inferred from either the agreement And also, most often than not, what is never written is payment. Once there's exchange of monies, the assumption is the property has passed. Okay. One other mean is that when when the goods are also in a deliverable state, for instance, the goods have been packaged nicely, they have been bagged, and they have been delivered, then we can say ownership has passed.
Right.
Yeah.
Thank you very much. You are still here on The Law. It is your legal light. It is your help law. And I'm sure that you're getting a lot of illumination. I'll make a confession to them once we step out of this room. I'm doing a pleading on a matter, and I just got something. Now, we are getting into Christmas. You're going to be buying stuff. And we just spoke about online. Many people are doing online purchases and transactions. So suppose I through online, I make a purchase of some good. I'm in Accra, and where I'm buying it from is from, say, maybe Bolgatanga. And by the time the goods arrive to me in Accra here, they are either expired, or some are expired, or maybe it's drinks, and some of the bottles are broken. Do I have protection under this law?
Yes, you do have protection under the law, because the issue of ownership again comes here. Now, the law allows that ownership is transferred, and so you see, sometimes it looks abstract, but the question of ownership, that is who owns the property at what point in time, will determine who has a right in the good or not. Now, the law allows that the parties will decide when it should pass, but if they do not, when the goods are delivered, that's where the ownership will pass. Now, if I order for a good from Bolgatanga, the understanding is that the good coming from Bolgatanga to Accra to me is still with the owner, the seller. He's the owner.
Okay.
I ordered for 10 bottles of, let's say, wine. Now, by the time it got to me, it's broken. The question is, did I order for broken bottles of wine? No, I didn't. So then it goes back to the fundamental right of the buyer, that the good must substantially correspond to the description he gave. I said I wanted bottles of wine. I didn't say I wanted broken bottles. So by the time it gets to me, if they are broken, the seller will have a question to answer. And since they don't meet my requirement, then I can reject it.
What if they delay and by the time they get to me, they're expired?
They delay. It still comes in because then the time of delivery is a condition of the contract. So if the goods should get to me by, let's say, 25th December, you delay and you bring it to me on the 30th. That's the first breach. Now, the second breach is that it's expired. It's not fit for purpose. Under Section 13, it means that it doesn't qualify. So either ways, the seller is in breach and I'm entitled to reject it.
Jude, does it matter that when I made the purchase, I instructed you to give the goods to deliver them to a particular driver? These days we do that. You say, go and do OA. Then we go and put it, or STC, and they bring it to me. Does it matter that I'm the one who instructed you where to deliver them to be brought to me? Does it also matter that by the time, if the goods are delivered at a delayed date, does it matter that maybe there was the car broke down on the way or something? Does it matter?
Yeah, it matters, and let me break this down. Kwaku has explored an aspect of it. One other aspect of it is the issue of risk. That is, which of the parties bears the responsibility for the damage, the deterioration, the theft, the loss, or the destruction in the goods.
Okay.
Is it a buyer or is it a seller? Okay. If it is the seller, that is the cause of this risk. Then what it means is that if monies have changed hands, it means that the seller is entitled to refund, and the seller can also not be entitled to claim for any monies. If it is the cause of the buyer can also not be entitled. If the buyer has received goods, the buyer must also return the goods. Okay, the buyer must pay for the goods rather. Sorry,
right.
But especially if the goods, the damage or the loss or the theft was the cause of the buyer. Now, when we talk about this risk, or because you mentioned the issue of delay and all that, and whether the goods were given to this OE or STC or what have you.
And I'm happy you introduced the question of stealing.
Oh, right. Oh, so this is what happens. In a typical sales transaction, I am the seller. I instruct, the buyer buys goods from me. And the buyer, so as part of our agreement, now let me just say this. The use of the word delivery in law means you deliver at the seller's premises. So let us say this is Joy Auto Parts. Maybe Joy deals in some certain cars. Okay, so I come to Joy, I buy a car, and Joy delivers a car. If our agreement doesn't mention anything, the obvious place is that Joy will deliver it here for me to be to take delivery of it.
Okay.
Unless the agreement tells me that, or tells Joy to deliver it at my place. When Joy is delivering the goods and the goods get destroyed and the goods get damaged, Joy is liable. That is the risk we are talking about. So Joy is liable. However, if there are no subsequent instructions and if the agreement didn't mention that, and as part of the sales, after the sales transaction had been concluded, I instruct Joy to deliver the goods to a particular known location. What happens is that at that stage, we have entered into an agency relationship.
Okay.
At that time, the buyer is the principal and the seller is the agent. So when and mind you, another principle of agency, the basic principle of Montgomery and United Kingdom Steamship Association, the act of the agent is the act of the principal. I mean, baseline agency principle. And then what it also means is that when an agent does something, it's the principal that suffers. Okay? And a third party can sue the agent, and third party can sue the principal can sue the third party. So at this stage, what it simply means is that between the buyer and the seller, the goods which are now destroyed because instructions came from a buyer after the conclusion of the contract, and the emphasis on after, this is very important, it is the buyer that becomes liable and not the seller. Okay? And again, and another point, because you made mention that when goods are given to a carrier, so the seller gives goods to OA or STC, the seller is still in control. Because the seller controls OA, the seller controls STC. Not that when we say control, we don't mean the seller is the owner of STC. In terms of the goods, it is not the buyer that is in control.
Right.
Unless it is the buyer that instructed for the goods to be placed by STC or OA or any other mode of transport. Okay.
Thank you
that
very
is basically
much.
what it is.
Thank you. And you're still here on the law. This is your legal light. It is your health law. And my guests are Jude Atakra Tofo and Kweku Atakra Jumo, who are the authors of Atakara and Atakara on goods, on sale of goods. Atakara and Atakara on sale of goods. And I can imagine how particularly students of the law are excited, and even practitioners also who are watching are excited to participate in this program today. So, as always, between now and when we draw the curtains, the phone lines are open. You can call and ask a question on the subject we are treating. Know your rights as a buyer. Know your rights as a buyer. So you can call in and participate in the discussion. But before we do that, we take a break. We'll be right back.
Battle of Wits, a contest among the smartest law students.
I was the first native of Ghana to be called
John Mensah Saba.
Thank you very much.
The legal arguments and the tricky questions are all rooted in law.
It's true or false? True. False.
We still had MPP versus Attorney General.
That's why I said the 10th December case.
You will not find that citation. Will you find that citation?
Ghana Bar Association versus the Attorney General.
That's incorrect.
Welcome to Season 3 of The Law Challenge.
I'm your quizmaster, Samson Ladi Anyanini.
The Law Challenge, legally speaking.
Much of what we do is about trust. So, trust us to give you the news and analysis.
The truth of the matter is that the MPP MPs themselves, they don't think that the e-levy is a good thing.
Out of 28 sittings, she wasn't present in any of them. Her longest consecutive absence without permission, obviously, is 28 sittings.
We are for the people, not the powerful. This is the Pulse on Joy News. Independent, fearless, credible.
It is not always black or white.
It could be black and white.
You want to ask why? Why not?
You want to have a say, so you take the microphone.
End of the day, they'll tell you, oh, about Faye, about Chun, they'll come and take pictures and all that. They don't do it.
There are always issues. Find those that matter to you
on the all-new AM show with Benjamin
and Bernice.
It is worth waking up for.
Welcome back. This is the law. It is your legal light. It is your health law. And we are privileged to have Jude Atakra Tufo and Kweku Atakra Jumo, co-authors of Atakra and Atakra on Sale of Goods, who are lawyers. And of course, I just said they are authors and they are teachers. I envy one of them. He's got how many LLMs? Like 3 or 4 of them. I did only one, and it was a whole lot of headache. Right. So now, you've spoken about the goods and having been delivered and all of that. But what in a situation where, say, I purchase a car, it's been delivered all right, so both of us have discharged our obligations, but within a short time, I detect, serious defects on the vehicle, and it's a brand new car that I bought. Do I have any protection from this law? Maybe it's overheating, it is leaking, and I've already collected it, I have paid for it,
Well, the answer to your question is maybe. You may have protection. And I say maybe because, and it brings us to what we discussed earlier, caveat emptor, caveat venditor. Now, the position of the law under Section 13 is that if you're purchasing a good, there's no implied condition on the part of the seller to guarantee its fitness, right? So that means that when I walk into the car shop that I want to buy this vehicle, the duty is on me, the buyer, to ascertain whether the vehicle meets my specification. I may have the duty to inspect it and what have you. Now, if I inspect the vehicles in good condition and I purchase it, I am liable for anything that comes to the vehicle. But sometimes with vehicles, they are what we call latent defects. There are some defects in the vehicle where by an ordinary inspection, you'll not be able to detect the problem. It may be an electrical fault or it may be something hidden in the engine somewhere. Now, if it's a latent defect, then there's a duty on the buyer. So then it means that with the buyer, there's a duty on the seller. So it means that for me, the buyer, my duty only ends by inspecting the vehicle to detect whether there are patent defect that I could see. So
patent and not latent.
And so if let's say the problem on the car was the handle, when I inspected the car, did I see that the handle had a problem? If I did and I chose that this is still the car I want, I can't come and complain later if, let's say, while drive, the handle just flies off. I can't complain because the caveat emptor comes in to say that let the buyer beware. Now, if whilst I was inspecting, everything was okay, I brought my mechanics, they checked, everything was intact. But it happened that there's a deep-seated problem. In fact, there's one case, we handled recently like that, where the person who purchased from a particular car shop, I'll mention the name, he informed them that I'm purchasing this vehicle for his business. He purchased a brand new vehicle. Just within 3 months, He drives just for about 5 kilometers, the car stops. The car overheats. He sees all the engine oil dripping. He calls them, they attempt at resolving it. He gets back on the road. In the next week, the problem comes back. Now, this is not ordinarily a problem of a new car. So it means that there was a problem in the car that the seller did not disclose.
That's right.
And as that now, the burden is on the seller to explain. So that gives the buyer the right to say that, yes, I inspected the car, but I couldn't have seen this problem in the engine.
In this case, I could get my money back.
You can get your money, because you can reject your good, get your money back, and maybe
it doesn't matter that I've used it for a while.
No, no, because I mean the problem is, and it should be taken on a case-by-case basis. It shouldn't be that I bought a car for, let's say, a brand you can use for 4 years.
Let's hold on. Theophilos, thank you for your patience. You're calling us from Bupe. What's your question, Theophilos?
Yeah, Thompson, I would really like you to let the Learned Council really expatiate on the difference between ownership and possession of goods. As rightly asked him, how is that as a buyer, I buy the goods, take delivery of the goods, and the ownership is still with the seller? It's a bit tricky, and I would like you to invite you that you really expatiate more on it so that we understand it more better. Thank you.
Thank you for your call. Okay, so I'd like you to respond to him, but conclude on the point that you were making.
Right, okay.
Yeah.
Yeah, so essentially, the point is that if the problem in the car is one that could have been detected by the buyer, caveat emptor comes in to prevent the buyer from complaining.
Right.
But if the problem was not one the buyer could have detected through reasonable examination, which we call a latent defect, then the caveat emptor comes in and the obligation is put on the seller.
All right.
So the buyer can reject the
Thank you. Before you answer, Theophilos, I have Elvis Boateng. So you note Elvis's question. Elvis, you're calling from Amasaman. What's your question?
Okay, thank you very much. My question is that I want to know if a buyer, describes to the seller the good is buying, and the seller supplies the good. I want to know if the description doesn't meet the exact good the buyer is getting. I mean, can the buyer reject the good?
Okay, thank you very much. I think that was already actually explained and answered. Right. So,
all right. So
yes,
if I can answer. So let me make it simple. Let me give an example. So with your OE example. So goods are purchased, they are put on board OE. The agreement between the parties is that the buyer had to pay before the goods be placed on board. And by that, the intention was also such that ownership would pass upon payment. Payment has been made. At that point, the goods are still with the seller. It means that the buyer is the owner of the goods. However, the law under Section 27 suggests that, or states actually that, even in such instances, the law does not really take into consideration who the owner is. He who is in possession and gets goods damaged or stolen or lost is the one who becomes responsible. So in simple expression, that is what I would say.
Add just a point. Now, the law allows that the buyer and seller can decide when ownership will pass.
That's right. Yeah. You actually stated that.
Exactly.
Right.
Sometimes the parties can agree that the buyer should have the goods in possession for, let's say, for 3 months on the trial run.
Great. I've also answered. You be my last caller. I'm very sorry. Also answer. You're calling from Kumasi Asafo. Let's hear you, Usu.
Good afternoon.
Good afternoon. Please, quickly, you have like 30 seconds.
Okay, please, may I know that can the seller have an agreement with the buyer concerning the latent effect? Maybe 2 latent effect agreement. Can we have a situation where we can have a latent effect agreement between the seller and the buyer? Let's say, assuming 2 latent effect agreement. So when you detect every effect, then you can return it to the buyer.
Right, but if the argument doesn't end because the two of you don't constitute a court or an arbitration panel or something,
So just to mention a point, I think the penultimate caller made the point that when a buyer describes goods and the goods are delivered and they don't meet the prescription, can the buyer reject the goods? Okay? So when the buyer describes, it is different from when a buyer informs the seller what he intends to use the goods for. There are two different things, okay? So when a buyer describes, it means that at that point, the buyer doesn't even know the goods which will be delivered. What it also means is that the buyer is only giving the specs. I want A, I want B, I want C, I want D. Informing that seller to go out there and go and look out for the goods which conform to those specifications.
Right.
That is why in Kweku's earlier submission, he used the expression to conform, to substantially correspond. So that is what we mean by buyer describing.
Right.
There's a provision in the law which looks exactly like that. Okay, like in section 11, you find the description of goods. That description is a description of the seller.
We have just a minute to go, and I wanted you to, because in this Christmas, people are going to ask, their seamstresses, tailors to make them stuff. And then I ask you to make it for me for Christmas, particular day 24th or something. And then before I say, Jack, I'm getting it in the new year.
Time of delivery in a contract is a condition. So if I tell you that I want it for on the 24th, and even with that, there are two points in there. The time of delivery and the purpose. I tell you I need my jacket or my attire for my Christmas. I tell you that I need it by the 24th. You decide to deliver it by the 1st. You'd have breached that agreement that we have, and the buyer is entitled to reject it.
Okay. So I reject it. I just get my money I paid you, or I get extra compensated for, because you have wasted my time and everything.
Yes, you're entitled to damages. So you reject, you can take back the attire, give me my money, but for that period also, you're entitled to damages.
Thank you very much. How time flies. We are out of time. Yes.
Just a point. Throughout our submissions, we made the point that we need a consumer protection law.
That's right.
The one major problem with our law is that the law was made for both the consumer and the businessman. And sometimes that is where the confusion is. The point we've made throughout for the past 1 hour is that when you go to the market to buy ordinary goods, and your obvious remedy is to reject, whereas the law also entitles you to terminate and bring further actions for damages. If you buy consumables, you won't be able to terminate and sue for damages.
All right.
Okay.
All right.
So that is something I wanted to draw your attention to.
Thank you very much. Thank you very much. Unfortunately, this is all time will allow us. Jude Atakrah-Tufo, private legal practitioner, lecturer, Central University. Kweku Atakrah-Jumo is also a private legal practitioner, lecturer, UPSA Law School, and they are co-authors of Atakrah and Atakrah on Sale of Goods. I'm Samson Ladi-Anyanini. Gentlemen, can't thank you enough. Thank you very much. But it does look like we may have to think about when we will do a repeat match. Thank you. Thank you. Right.